The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. All right, we will hear first from Mr. Williams.
Good morning, Your Honors, and may it please the Court. Chadrick Fulks and Brandon Basham have convictions under 924C and 924O that are invalid. Now, there are two potential crime of violence predicate offenses that could form the basis for those 924 convictions.
Are you representing Mr. Fulks or Mr. Basham or both?
I am representing Mr. Fulks. However, I'm presenting argument on behalf of both Mr. Fulks and Mr. Basham.
Okay.
And Your Honors, those two potential predicates are carjacking and kidnapping. Now, neither carjacking nor kidnapping satisfies the force or elements clause of 924C. So neither can be valid predicate offenses for the 924 convictions for either
We had a
defendant.
decision in Draven that said that carjacking did meet the force element.
And Your Honor, I think there are other decisions. Draven relies on Evans, and Evans is the court's precedent, that Draven relies on, that I believe Runyon also relies on. And that precedent has been rendered invalid by the advent of Borden and the advent of Taylor from the United States.
Draven came after those, right?
It did, but Draven imported, meaning relied on Evans, and relied on Evans as binding. And we believe that neither Draven and certainly not Evans has dealt with the challenge that we make to Evans under Borden and the challenge that we make.
So in your view, Draven is simply wrong?
In my view, Your Honor, well, clearly we believe that Draven is wrong, but also that Draven relies on a precedent that has been invalidated by intervening Supreme Court precedent. And
So what happens if we disagree with you?
well, if the court disagrees with us, then that doesn't end the defendant's request for relief. If the court disagrees with us and believes that Evans remains valid and Evans and Draven are binding, then Mr. Fulks and Mr. Basham are still entitled to relief. And the reason for that is that in both defendants' cases, and they're slightly different situations.
The threshold question here is that Taylor dealt purely with attempt. Taylor did not deal with a completed carjacking. And that being the case, Evans and Dayton would remain good law because we don't likely presume that circuit law has been overturned.
Well, and Judge Wilkinson, I think that Taylor undermines Evans for a number of reasons. The fact that it found that an attempted taking or an attempted threat to take is not a crime of violence under the Elements Clause does undermine Evans because there is an attempt clause in the carjacking statute.
Well, but I mean, at common law, attempts and completed crimes are treated differently.
Well, and I would agree with the court that they are treated differently at common law, but in the
When you come to this statute, attempt is set off by commas and everything, which would further underscore that the common law concept was carried forward.
And, Your Honor, I would respectfully disagree with you. I believe that while there certainly are commas there in the statute, this court has found, and I believe the example we gave was United States v. Royal, where there was an indivisible statute, where the clause in question, where the government argued that the divisible clause in question was set off by commas, And this court still found that it was an indivisible, statute. And so even if the court, even if Taylor focused solely on attempt and an attempted threat, that doesn't.
Just taking Taylor's own terms, that's what it is. That's what it focused upon, because the reason that attempt and completed crimes are treated differently is that they have different elements. And all attempt, a completed crime requires at the time that the crime be complete, and attempt simply has as an element a substantial step to the completion of a crime. And those are not the same things. Those are different offenses.
What?
And they're sentenced differently, and it would be an odd holding of our court to say, oh, there's no difference between an attempted crime and a completed crime. I just can't believe it.
Well, and Judge Wilkinson, our point is that it's a statute-by-statute analysis, and to take the court's point about their sentence
Right,
differently.
And so I said, okay, but the statute, we shouldn't presume that the statute is in contrary to common law, and especially when the word attempt is set off by itself in commas, and you have the way the statute is written, and you have the tradition of common law, and you have the different elements, and you have Evans and Drayton in our circuit. You're up against an awful lot on 3 or 4 fronts.
And, Your Honor, we don't think that we're up against an awful lot on 3 or 4 fronts. And our point is that it's got to be a statute by statute.
I don't expect you to agree with me on anything.
Well, hopefully we would agree on a grant of relief. But the statute is our point is that it's a statute by statute analysis. And in this scenario.
That's what I was trying to do.
Yes. And in this scenario, the court mentioned different penalties. Carjacking by attempt versus carjacking by actual taking, that's the same penalty. That's a point that, that I don't think is undisputed.
It can be concurrent sentences, or it can be the same penalty. But that doesn't mean that they're the very same crime. That's not the sole test.
Well, and Your Honor, I think our point is that it's a number of elements, and the commas don't do it, and that's under United States v. Royal. The fact that there are.
I might not do it, but they might help.
Well,
you have to look at them in context.
Well, I believe you do have to look at the context, Your Honor. And the context of this statute is that section where the attempt clause exists in is force and violence or intimidation or by attempt. And this court has found that those force and violence or intimidation, that those are 2 means. And so it would not make sense for those 2 things to be 2 means of committing the same element, and then for Congress to add on a separate element as opposed to just adding.
It's hard to look at all this in an isolated situation. These guys are on a crime wave of the worst order. And they carjacked this woman in Conway, South Carolina. They kidnapped her at the same time. They took her into North Carolina. They raped her. And that was just part of what their crime wave was. They started in Kentucky, and then went to Indiana, and went to West Virginia, where they killed a woman, and then went to South Carolina. Then they pulled this off. Then they went back to West Virginia and Kentucky and Ohio and Indiana.
And
I'm a little bit familiar with the facts of this thing, because I had Mr. Folk's case 20 years ago.
And Judge King, my response would be, and this is not.
The facts are terrible, and I admire you, what you're doing. I mean, you're a fine lawyer, and I know you're into it now, and I really admire what you do, and I appreciate you. But it's an uphill grind.
About a bad one, Judge King has summarized it better than I could. But I've never seen a case like this where the facts jump out at you so, And, you know, to think of these different women that were, what it must have been like for them to have been carjacked and taken into the woods and raped and murdered. And then we are supposed to sit here and say that there was no predicate crime of violence? I mean, at some point, reality has to break through. And we need to connect with what's actually happened here. And I understand that the categorical approach says, oh, you shouldn't look at all that, but it's impossible not to look at it. It is impossible not to let the reality and the horror that was visited upon woman after woman after woman going through the most frightening experience that anyone in this courtroom could even imagine. And then we are asked by an able lawyer to say, oh, all this is not a predicate crime of violence. There's no violence. There's no violence here. I mean, how far have we wrapped ourselves in our own little cocoons and taken leave of the reality that the jury understood? That's why in Mr. Basham's case, I realize Mr. Folks pleaded guilty, but that's why in Mr. Basham's case, the jury understood exactly what Judge King and I have been talking about.
We're supposed to look at it in isolation. That's what your argument needs to be. And the question is whether under the law we're entitled to do that or required to do that.
And I think
And Judge Anderson, who presided over the only trial, the one that Basham had, but he presided over the guilty pleas too, as I recall, of folks. And he handled these collateral proceedings, and he's a very careful judge, studious judge. And he wrote an opinion that you say is flawed, and you need to say it's flawed. But I thought, you know, it's a good argument to be made that Mr. Booth's going to make, that Judge Anderson was right.
And so Judge Wilkinson and Judge King, to both of your points about the facts of the case, and Judge King, to answer your question, I think the court, and I'm not trying to minimize the seriousness of these crimes, but the court is not permitted to look at the facts when embarking on a categorical examination. So, you know, respectfully, I say that.
If it's divisible, we are we?
Well, it's divisible. The court is permitted to look at the underlying Shepard documents to
It
determine.
says we can take a peek.
Yes.
And what's a peek?
well,
A peek here, I mean, but yeah, I know what you're saying.
Well, one of the things,
But like Judge Anderson, I saw a lot of this 20 years ago. And I'm from West Virginia, and I remember the event up there. This was a young 19-year-old co-ed from Marshall University. And her body was never found, even though folks tried to help him find the body, to his credit. Supposedly he helped him, tried to help him find the body along the Ohio River there somewhere next to Huntington. But they were unsuccessful.
And so, I'm sorry, Judge Agee, you had a question.
one of the things that we do look at in trying to make these calls is how is the crime charged? How is it instructed? And if I'm remembering the record correctly, either the district court found or the government argued or both that they could find no instance, and you tell me if you have one, where these two crimes, attempt and carjacking, completed carjacking, are charged together, that they're always charged individually, and they're instructed that way. And that's an indicia that you have two separate crimes. Do you have a case where there's a joint instruction?
And yes, Your Honor, we've provided those in our initial brief. We cited them in our initial brief. Example of jury instructions where the jury was not required to agree on whether it was carjacking by attempt or carjacking by actual taking. And we also proffered the model jury instructions from the District of South Carolina, where again, the jury is not required to agree on whether or not it's carjacking by
The government
attempt or taking.
rejoined that instruction had never been used that they could find.
Well, and then we provided examples that we have cited. All the examples aren't in the District of South Carolina, but they are examples to answer the court's question. And that's the issue that's dispositive.
Where in your brief do we find this?
So, Your Honor, I will check, and I can have that page cite for you by the time I circle back around on reply. And I'd also add, I see that I only have 10 seconds left on my time. So even if the court doesn't agree with us on divisibility, we would still submit that carjacking is not a crime of violence because it doesn't have the requisite mens rea. And I'm sorry, I'm in the red. Could I just, may I be permitted to finish my sentence or comment?
All right. Thank you, sir. You got some rebuttal time.
Okay, thank you, Your Honor.
Mr. Booth.
May it please the court. Carjacking under 2001-19 is a crime of violence because it is divisible into completed carjacking and attempted carjacking. Attempted carjacking is a distinct offense, not a method of committing carjacking.
Can you lower the microphone?
I'm
just a
sorry.
little bit?
Can you hear me now, Judge Wilkinson?
Perfect.
Okay. The reason is that at common law, an attempt offense was a distinct offense. And under the Supreme Court's decision in Castleman, Congress presumably adopts the common law definition of an offense in its statutes. Fultz and Basham have not offered any real reason to overcome that presumption. Second, under the Supreme Court's law in Taylor and in this court's precedents in Pratt and other cases and other Court of Appeals opinions, an attempt is distinct from a completed offense because it requires two elements that are not found in a completed offense: a substantial step to commit the offense and specific intent. That's further indication that there is no rebuttal of the presumption that Congress intended to adopt the common law definition of carjacking. Three, the standard jury instructions that are used in the federal courts tend to separate the two. And in fact, as I cited in my brief, the standard jury instructions generally have a separate section of jury instructions on attempt. And fourth, attempt is separated from the other offense by the word or. And in the Allred case, this court, an opinion written by you, Judge Wilkinson, indicated that the presence of the word or, while not conclusive, is nevertheless some indication that the offense before or and the offense after or are separate offenses. And then finally, disjunctive. Again, the court's right that they are not, that's not the most conclusive test, but we submit really, in our view, the conclusive tests in our favor is that the common law version is that attempt was different and that Congress presumably adopts the common law definition of offense statute. Nothing the defense has shown can show that that presumption has been overcome. Let me turn then to the second issue, if there are no further questions on the first, as to whether or not the Evans decision, which upheld Section 2119 as a crime of violence, has been overturned by Taylor, which rejected the realistic probability test in defining crimes of violence. In the recent decision in this court...
Didn't Mr. Fuchs plead guilty to carjacking?
He did, and that goes to our third argument, as the second argument as to why that in the event that the kidnapping offense is an invalid predicate,
But doesn't that go, if he
carjacking.
pled guilty to carjacking, it goes to the question of the completed crime, and it also goes to the fact that this was not kidnapping.
That is correct, Judge Wilkinson. That also goes into the argument they have made that even assuming that kidnapping is not a crime of violence, you can't rely on the carjacking offense here. The reason is that well, I will come back to that in a second, but the point is he did plead guilty to carjacking, which shows that he did not plead to kidnapping alone, under this court's decision in Draven, under this court's decision in Tipton. But I did want to go back for a second here as to show why Evans has not been overruled by Taylor. That's because this court's recent decision in Green rejected an argument that a decision of this court that had upheld an offense as a predicate was invalid because it had relied on a previous Fourth Circuit decision that had upheld the same offense using the improper realistic probability test, where the most recent decision did not use the realistic probability test in its decision. Well, in the Evans case, while it cited the court's previous decision in McNeil, did not use a realistic probability test at all. And so we would submit that under Green, Evans has not been overturned by Taylor. And if I can add one little point, the only reference to the sort of realistic probability test that was done in McNeil was a rejection of the defendant's argument that the use of poison didn't constitute a use of force. Well, it turns out that in the Castleman case, the Supreme Court also rejected an argument that the use of poison was not a use of force, but it did not use a realistic probability test at all, which indicates the court in McNeil could have rejected that argument about poison without using a realistic probability test at all. And in fact, some cases after Taylor have found that there can be intimidation without using a realistic probability test. So therefore, we don't think that Evans has been overruled by Taylor at all. We also don't think that carjacking has been overruled by Borden. Borden held that a crime that was defined by a reckless mens rea is not a crime of violence. But
You said carjacking, you mean either Evans or Draven was not overruled by Borden.
Well, neither Evans nor Draven. I think also there are subsequent cases that have cited, I believe the, the Runyon cases. So, I mean, this court has repeatedly upheld Evans, and none of those cases rely at all or even mention the realistic probability test.
In order to have a carjacking offense, there's got to be some threat or intimidation. And that takes you right into the language of the Elements Clause.
That is correct. And with respect to intimidation, that part hasn't been overturned. Carjacking hasn't been overturned by Borden because this court, I believe, also in McNeil indicated that a defendant has to know that his conduct is good.
There's no question of negligence here. Looking at the facts that we can look under Shepard and the modified categorical approach and the nature of the offense of conviction, there's no negligence here or recklessness here. This was a deliberate, knowing, intelligent attempt to visit an unprecedented amount of cruelty upon the victims. And that's not reckless, that's intentional, if anything is.
Well, right, for purposes of the categorical approach, we look at always at the elements of the statute. And there is no part of this statute that has a reckless element to it at all. Remember, in Borden, the Supreme Court was considering a Tennessee statute that had an express recklessness element to it. Nothing in Borden, nothing in carjacking has a recklessness element whatsoever. I mean, there's a specific intent element, there's an intimidation element, and this court's decisions and courts from other circuits have held that there's no recklessness part at all. Again, with respect to intimidation, this court said in McNeil it has to be knowing. So we don't believe that carjacking has been overruled by Borden. If I could go to the second issue, the defendant's 924J convictions were properly based on a carjacking predicate. And the reason is that on collateral attack, when a Section 924C offense is based on a valid and then invalid predicate, the defendant has the burden to show more than a reasonable possibility that the jury relied only on the invalid predicate. That would be the kidnapping, which we have conceded is not a crime of violence. But he can't show that here for two reasons. First, both defendants were independently convicted of substantive carjacking in count one. So that shows that the jury did not rely at all on the kidnapping offense as the predicate in the 924C offenses. Second,
Kidnapping and carjacking here were basically inextricably intertwined when you come to the facts, weren't they?
well, that is also part of the test to determine whether or not the jury relied solely on kidnapping. The test in this court, in Draven, in Said, and again in the Tipton case, is that if the two offenses are inextricably intertwined, that shows that the jury didn't necessarily find the invalid predicate only. And not only do we have this as a matter of fact, but the jury's special verdict form at the death penalty proceedings specifically found that the carjacking was committed during a kidnapping, which shows that the offenses were factually intertwined, which defeats the defendant's claim. The defendants have relied on Runyon to say that the court's decision in Draven and Tipton are probably incorrect.
Permissible, is it not, to look at the evidence before the jury?
Pardon me?
It is permissible to look at what the evidence was before the jury in the Basham case.
Well, it is important for purposes, again, in determining whether or not the crime, the 924C, which is based on a valid predicate and an invalid predicate, this court and other courts have said that we can look at whether or not the two offenses were inextricably intertwined, which is some review of the evidence that was presented at trial. So there is.
So for the Folks case, we can consider the evidence in the Basham case?
No, in the Folks case, you can consider that, first of all, well, two things. First, he pled guilty to substantive carjacking, and the jury's
He
verdict.
pled guilty, am I correct? He pled guilty straight up?
Straight up, that's correct. So he pled to everything.
There's no plea agreement to worry about.
No, he pled guilty straight
Pled
up
guilty
and
straight up to 8 counts.
8 counts. And one of those, I'm sorry, I didn't mean to
think
interrupt
At
you.
some point, I saw something in some papers, he didn't want to go on with any court proceedings.
There have been at some early part of the proceedings in which but he ultimately pled straight up to all
That
8
came up
counts.
during one of these earlier cases.
That may be. But the point is, he pled guilty.
Folks was different than Basham.
Basham went to trial,
Basham
Foltz
went
pled
to
guilty.
trial, and all of it was before Judge Anderson.
That is correct. But for purposes of determining whether or not the evidence was intertwined for the kidnapping and the carjacking, it's not just my review of the evidence. The fact remains that the jury's special verdict form found as an aggravating factor that the carjacking was committed during a kidnapping, which is further evidence that the jury found that the offenses were factually
That was in
intertwined.
the Basham case.
In both cases, the jury, as an aggravating factor,
The jury wasn't in there was no jury in the Folks case.
there was no jury at obviously, the previous, but there was a jury at the sentencing proceeding. You see, in other words, the jury had.
with you, okay.
Right. So what happened, the jury returned a special verdict form at sentencing, and what I'm relying on is that as an aggravating factor, the juries in both the Basham case and the Folks case found that the carjacking offense was committed in the course of a kidnapping, which is, again, that just further evidence that the two offenses were factually intertwined. The jury made that finding. Again, the defendants have relied on Runyon, but Runyon, that's misplaced because Runyon found that both predicates were valid to support a 924C offense, so it was unnecessary for that court to conduct a harmless error review. So Runyon doesn't conflict with this court's decision in Tipton, Draven, or Said.
And the point is, it could not have rested on kidnapping alone.
That is correct. There's no chance in this case that the jury's verdicts at the death penalty could have relied on kidnapping
Is
alone.
that because of the evidence or because the two crimes were so intertwined?
Well, first of all, again, both defendants pled guilty to substantive carjacking, which shows that the jury did not necessarily found that this was a crime, that the predicate was kidnapping alone. They can't meet the reasonable possibility test established in Draven, Said, and Tipton. The second thing I said, the second point we were making to buttress that was the jury's verdict at the penalty phase, which showed that the carjacking was committed in the course of the kidnapping, which again is just further evidence that these two offenses were intertwined. And if you look at the evidence at trial, I mean, there was a video surveillance that was introduced at Basham's trial, which shows that the carjacking and the kidnapping were committed at approximately the same time. The third issue the defendants have argued is that the death sentences cannot stand if the court reverses the 924C counts. Our argument is that the death penalty sentences in this case were not based at all on the 924C counts. And the reason is that at sentencing, the district court instructed both juries that it could only impose the death penalty if it found a threshold age requirement, an intent factor, statutory aggravating factor, namely the kidnapping, non-statutory aggravating factors, and certain mitigating factors. The jury was specifically instructed that it could not find any aggravating factors on its own. The jury presumably followed that instruction, and that's confirmed by the special verdict forms that follow the instructions. There's no indication at all in those instructions that the jury based its death penalty findings against both defendants in any way on the 924C convictions at all. I mean, they're nugatory, they don't count. The defendants have argued that the sentencing package doctrine should apply here, but in our view, the sentencing package doctrine doesn't apply here because the death penalty sentences were imposed by the juries and the non-death penalty sentences were imposed by a judge. And so you don't have a package here that needs to be unlaced or unraveled because the jury's death penalty sentences stand alone. He also argues that the evidence of the firearms was improperly admitted at the sentencing proceedings, but it was relevant evidence because counts 1 and count 2, the specific offenses, the death penalty of eligible offenses, showed that Basham at least had a firearm when they kidnapped and carjacked the victim. So that was proper evidence to show how the offense was committed. And also that evidence was properly admitted to show some of the non-statutory aggravating factors that involved the crime spree that led up to the kidnapping and carjacking of Donovan. And the third thing is the defendants never disputed that they had firearms during their crime spree. But you know, their offense was somebody else did it, it wasn't me. I didn't have the specific intent to kill her. They basically conceded that they used firearms. And so there was no problem here for the death penalty sentences in this case, and we would ask this court to affirm. If there are no further questions, I'll sit down. Thank you.
We have no further questions.
Thank you, Your Honors. Judge Agee, I'd like to respond to your question. Pages 19 and 20 of our initial brief is where we list the examples we found of
I found that.
Okay.
I think Mr. Booth confirmed that their position was that the completed carjacking and attempted carjacking are generally charged and instructed differently, not exclusively.
Thank you, Your Honor.
That's his view anyway.
Okay, and our response to that would be, you know, the question is, what is it required to be charged as?
Sure.
And if the jury is not required to agree on attempt versus completed or attempt versus by actual taking, then under United States v. Mathis, that is the end of the inquiry. And it's our position that the jury is not required to agree on this as demonstrated by the examples we provided and the model jury instructions from the District of South Carolina.
But I'm not sure that I understand your Borden argument because, as Mr. Booth was saying, when you look at the carjacking statute, there's no element of recklessness or negligence about it. It was a specific intent statute which required intimidation or threats, and that the language of the statute here doesn't. It hooks up with the elements clause, and it really doesn't permit a conviction on the basis of some lesser mens rea like recklessness or negligence.
And if I may respond, Judge Wilkinson, you know, clearly we disagree with the government in that analysis. Under Holloway, which establishes...
How can you disagree in light of the wording of the statute?
Because Holloway defines intent for the carjacking statute. And Holloway only requires that the defendant have conditional intent with the use of force. So I could be guilty of carjacking and commit a carjacking without using intentional force or knowing force if I only have the conditional intent to use that force should it be necessary to effect the carjacking. And that makes room for recklessness, that makes room for negligence. And because Holloway defines intent, it expands on the definition, it is less demanding than the plain language of the statute.
You have to go through a lot of steps to get where you're going.
Well, Your Honor, I don't think you do, because the Supreme Court is pretty clear on what the intent standard for Holloway is. And under Taylor, the only thing we're supposed to do.
The Supreme Court's clear, and the statute is clear, and the statute matches up with what the Supreme Court in Borden wanted.
Well, except the statute also, Holloway says this is what intent means, and intent means conditional intent. And carjackings have been prosecuted with a condition.
It's like the statute took the words right out of the force clause.
And if the statute required intentional force that matched up with the force clause, then that would be true. But Holloway, has told us that it doesn't. That is a less demanding standard. And so in many senses, we can't have it both ways. If it is a less demanding intent standard for carjacking, which it is a conditional intent standard.
But just the word of the statute, you have to know what you're doing in order to commit a carjacking offense. And in order to be convicted of carjacking, you have to know what you're up to, and you have to intend what you do. And to say that, the evidence matches up with the statute because the mens rea of these particular defendants and dragging these women out into the woods and raping them and killing them matches up with the kind of mens rea and conduct that the carjacking statute sets forth. I mean, I just don't see how we can possibly say, oh, well, they were reckless about the whole thing. Well, they weren't, and whether I look at the facts here or whether we look at the statute under the categorical approach, the end game is the same. They knew what they were up to. It wasn't any entrapment or negligence. They knew what they were doing.
And Judge Wilkinson, I'm in the red. May I just respond to the court's question?
Sure.
Okay. That, as the court can't look at the facts when making a categorical analysis determination, and when we look at the elements of the statute as defined by Holloway, which is the controlling law in the United States, the only requirement is conditional intent. And conditional intent makes room for the reckless or negligent use of force.
All right. Thank you, sir.
Thank you, Your Honor.
I'll ask my co-panelist, Judge King, do you have any further questions? You okay? JJ, we're fine. And I want to thank you very much. And if you'd like to come up and fist bump me, but let's bump. Don't give me a roundhouse swing. Thank you very much.
Thank you, Your Honor.
Mhm. Come on up, Mr. Rousseau, and we'll hear from you.
Good morning, and may it please the court. This case presents two critical issues. First, whether the immigration judge properly determined that Mr. Mohammed Kouyate's conviction qualifies as a fraud-based aggravated felony, and specifically the loss amount and how that was calculated. And second, whether Mr. Kouyaté is more likely than not to face torture if forcibly returned to Guinea based on sources of torture that were not properly aggregated by the agency in this case, specifically the political notoriety of a son of a former prime minister and the documented country conditions contained in the record and offered by Mr. Kouyaté that show that family members of political actors are often used as leveraging tools to exact revenge and also to obtain political retribution by other means.
But he produced no evidence that he himself had ever been threatened.
That is correct. But in this case, the fact that his father was the leader of the country, was a diplomat, also the head of the United Nations Syndicate for the African Union, and also founded a political party, finished fourth in the 2008 presidential election, receiving over 1 million votes in a country that has over 13 million people. The fact that he is the only son whose name is strikingly similar to somebody who led a country of 13 million people should in and of itself.
Haven't we been instructed by the Supreme Court that the standard of review of these CAT claims, and I'm taking the language out of the Supreme Court, is highly deferential?
Yes, Your Honor, that is correct. It is highly.
Not just deferential, but highly deferential.
Yes, but as Justice Kennedy said in his final immigration opinion, reflexive deference is not the type of deference that any circuit court should engage in when evaluating an agency.
It seemed to me you were talking more about general conditions in Guinea than you were about any particularized injury.
Well, there were particularized injuries to his father while he was in Guinea, both before and after his tenure as prime minister. That should in and of itself.
And how long ago was that?
Over a decade. But the attenuation of time.
Yes, our precedent says that the lapse of time is a relevant factor.
Of course, it is a relevant factor.
And that's a while back.
Indeed. However, as I invited the court to engage in a hypothetical I posed in my opening brief, the family members of our former leaders, all the way back to Chelsea Clinton, are going to be recognized to some extent and can be used for political means. And additionally, we all know it's well settled, right, that the nuclear family is the prototypical social group. Well, that's because of...
I want to come back to our precedent here because the Ortiz Cruz case said that this court has repeatedly recognized that the passage of time is appropriate to consider when determining whether an applicant is satisfied his burden of proving the likelihood of future torture. And here that is a good bit of time that has passed since this gentleman's father was active in Guinea politics.
That is correct, Your Honor. And I'm not.
How do we, given the relevance of that factor under our precedent, how do we overturn the BIA when the standard is supposed to be a highly deferential one?
Because this person is a historical figure in his country. Children might learn about him in school. The notoriety of his father is enough to overcome the temporal attenuation and how that causes the court to pause.
But is there anything specific that you have to go on?
In what respect?
It's all speculative.
Not with respect to what has happened in the past. There's country conditions evidence that directly implicates the father. Pictures of him being attacked in the streets during protests, and also his actions on behalf of the political party that he founded.
You have to prove it's more likely than not that he would be subjected to torture. But the BIA was saying here that you've got to come back with something specific that was directed against either the father or the son. We've never permitted general arguments to carry the day. We have required some sort of particularized showing. And given the length of time and the rest, that seems to me difficult when the Supreme Court has told us that our review of the BIA on cat claims, I'm not talking about asylum, I'm talking about cat claims, is supposed to be highly deferential.
Certainly, Your Honor, and I'm not seeking to diminish the highly deferential review that this court must engage in. I'm simply asserting that the unique circumstances of this case, the political instability, the military coup in 2021, the documented country conditions evidence from the state.
Sounds like you're willing to, you want us to look at it de novo, disagree. You presented all this stuff to the IJ and the BIA, and they didn't accept it as enough. It wasn't enough evidence. And you want us to look at it, take a fresh look at the whole thing rather than defer.
Mr. Quixote was pro se throughout his.
Rather than rather than highly defer.
I'm simply arguing that the sources were not properly aggregated. The analysis is flawed, not that the conclusion is not supported by substantial evidence. The fact of the matter is that all sources, and in this case, the motivations, which is not generally something that you see in a cat claim or something that is properly weighed or even relevant in a cat claim. But here, because of the notoriety of the individual in question, you have...
Counsel, excuse me.
Oh, I apologize, Your Honor.
You have here an information that indicates this individual has, on his record, 14 car thefts. Is that correct?
The offense related to improper or fraudulent credit applications to obtain a vehicle, but they...
There are 14 car thefts.
Yes, Your Honor.
Right? Even given the fact that I am not sure that Congress would have wanted someone to be ruled non-removable after 14 convictions for car thefts, I'm still willing and obliged to take the merits of your cat claims seriously. But as my colleague has pointed out, we are not the ones taking the initial look at this. We have not heard the evidence. The court, the BIA below and the IJ have a far more detailed understanding of it than we do. We are an appellate tribunal, and we, as my colleague points out, we can't just saunter in and take a de novo look at this whole proceeding. And there's the BIA did not run off the rails as a matter of law. They took into account the passage of time about the events that you were complaining. And our precedent says that's perfectly fine to do. And our precedent says further that general conditions won't cut it, that there's got to be some sort of particularized showing that this individual, because of his father, would be likely to subjected to torture upon his return. And it's a factual question. And the BIA said no. And so where do we get the authority to just do all this first instance? Look at these cases.
Yes, Your Honor. He is part of a pattern of similarly situated individuals that the State Department has concluded, and in the most recent country report, that there are that family members of former political leaders are often sought after for ransom or revenge or for political gain. That places him in a particularized vulnerability that is not common in a typical civil strife situation. And additionally, the fact that—
And you presented all that to the immigration judge, to the IJ.
Yes, Your Honor.
And you presented it to the BIA.
Yes, but
And they both rejected it as insufficient.
while also erroneously framing, though, the visit of the mother, as they viewed as highly dispositive, as something that showed that he wouldn't face any threat, when in fact he was born out of an affair with his father and his mother, which is why there was no interest in his mother, because she was never the first lady, so to speak. But turning to my second major point, though, Mr. Quixote was pro se before the board as well as before the immigration judge. And this court needs to consider how Quinteros, this court's opinion, in which an immigration judge has an affirmative duty to help develop the record with respect to the labyrinth of complexity of a protected ground in Quinteros, but here you have the aggravated felony determination, specifically the loss threshold, that was never properly underscored, highlighted, or even stated or framed for him to go into—
The immigration judge has an affirmative duty to rule in your favor.
No, Your Honor. I'm saying
That's what I've been hearing.
that complex legal issues that a layman has no ability to become informed on, just like Judge Dennis in the Fifth Circuit said after WIC-HOB, which I would submit catalyzed this entire inquiry as to the immigration judge's duty to play an active role in not only fact-finding and developing the record, but also advising or at least pointing in the right direction how a pro se respondent can colorfully and artfully, to the best of their layman ability, defend themselves against deportation. And when you have
What was he supposed to do here? I mean, you've got all this essentially uncontested evidence about all these financial crimes. I'm somewhat of a loss as to what sort of mentoring he's supposed to do.
I would point to the Second Circuit's decision in Ramper.
Tell us what he was supposed to have done in this case.
The immigration judge?
Yes, under your theory.
Yes, I would submit that at least identification of the circuit split or the complexity of the loss threshold.
Split on what?
The loss threshold and what is appropriate to rely on with respect to the actual loss and how restitution exclusively is not appropriate, as well as the statute's language, which is what the transcript reflects the immigration judge.
How does he do that without, in effect, stepping down from the bench and becoming the alien's lawyer?
To engage the respondent in the discussion instead of exclusively discussing it with the DHS trial attorney and saying, oh, well, we have this statute that requires $100,000 under Maryland, and we also have this restitution amount, so of course the loss threshold is satisfied. when you have other courts that have said, well, restitution, we need to see how that is calculated. We need to see if actual loss is what arises to $10,000. Because restitution under common law includes compensation, reparations, loss of value, not simply, and making the individual whole. So it is a broader concept than loss and involves many other remedial measures than simply trying to remedy the loss amount. And finally, I would simply,
Well, if you know, if there ever were a situation where somebody was convicted of an aggravated felony, which as we know is a deportable ground, this would appear to be it, because the federal limit on the aggravated felony, as you well recognize, is $10,000. And this individual was sentenced under Maryland law to 15 years. And that under Maryland law had to be over the $10,000 federal limit, which is the limit for an aggravated felony. I mean, he had a 15-year sentence, which under Maryland law reaches the aggravated felony threshold. And then when you add the restitution to it, I would say this individual probably $50,000, $100,000, I don't know what, but it's way, way over what's necessary for it to find an aggravated felony.
yes, Your Honor, I see my time has expired. May I respond to your question?
Yeah, sure.
Thank you, Your Honor. You are correct that the statute suggests that the loss threshold has been met. But in this case, the record demonstrates we do not know which victim lost $10,000. We all simply know that in the aggregate, there was this restitution amount applying to all victims. The Supreme Court in Newan demands more.
But he could not have been sentenced to 15 years under Maryland law unless the amount that defrauded was over $10,000. It would be an impossibility.
Then Maryland procedural evidence such as jury instructions should have been provided by the government so as to support that conclusion, instead of it just simply being inferred with the pro se respondent. The analysis in this case was,
Where's your client right now?
he is detained.
Pardon?
Detained?
He's in custody
Yes, Your Honor.
of the Maryland authorities in a Maryland prison?
No, Your Honor. He's under the custody of the Department of Homeland Security.
He's in the custody of the United States. What happened to his 15-year sentence?
He served it.
He served it all?
Correct. If I have no further questions at this time, I do have some rebuttal time, but thank you. And
Yep.
Now,
Good morning, Your Honors, and may it please the Court. Corey Farrell on behalf of the Attorney General. In this case, it was petitioner's burden to establish his eligibility for relief and protection from removal. This includes showing that he was not convicted of a disqualifying offense and demonstrating his eligibility for deferral of removal under the Convention Against Torture. The immigration judge here correctly found petitioner ineligible for asylum and withholding of removal because he was convicted of a particularly serious crime, and petitioner did not challenge this determination before the board. Moreover, the record in this case does not compel the conclusion that every other reasonable fact finder would have granted petitioner's request for deferral of removal. Petitioner's speculation that upon his return to Guinea, he would be linked to his father and tortured as a result by or with the acquiescence of the government is unsupported by corroborating evidence and insufficient to satisfy his heavy burden of proof. And as Your Honor, Judge Wilkinson noted, we have lots of general evidence in this case about country conditions in Guinea. But what we are lacking here is evidence to show that petitioner himself would face a particularized risk of torture. Yes, his father was a political figure in Guinea. There is no dispute about that, and the agency considered that fact and recognized that he was the former prime minister. But none of the evidence shows that anyone in Guinea is interested in harming petitioner at this time due to his father or any other reason. The immigration judge did exactly what is required of a fact finder here. He considered the testimony of petitioner, and petitioner called 2 witnesses here to testify on his behalf. Petitioner submitted evidence in support of his claims. The immigration judge developed the record through questioning, and so the agency considered all of the evidence presented. The agency recognized that it needed to consider the possible sources of torture in the aggregate, and the agency considered all of that and concluded reasonably that petitioner did not meet his heavy burden of establishing his eligibility for deferral of removal.
Mr. Russo says that the immigration judge needed to do a lot more. What's your response to that argument?
The record here shows that the immigration judge did what was required and fully developed the record. I would also note that this issue was never raised before the board, or I don't believe before this court until the reply brief. And so that issue was not exhausted about the immigration judge's duty to develop the record. But nonetheless, I will say if you review the record in its entirety, it shows that the immigration judge did what was required. He advised petitioner on his ability to present witnesses, to testify on his behalf, to submit evidence. He accepted the evidence, and he fully considered it.
That particular argument, I assume you would say, is simply waived.
Well, first I would say it was unexhausted because it was not raised before the board, and also waived, Your Honor. Correct. So I believe on the CAT claim that the record simply does not compel reversal of the agency's decision in this case. I also would like to turn to the particularly serious crime issue. The government's position is that issue was also unexhausted before the board because petitioner did not challenge the immigration judge's determination that his conviction constituted a particularly serious crime. And he's raising very precise arguments now before the court, which were never presented to the board. And the board explicitly found that he waived that issue.
All right, at this point, I'm going to ask my colleagues if they have some questions of you. Judge King, you're fine. No Judge, we have no questions, thank you.
Thank you, Your Honors.
Mr. Russo?
Following WYCHOB, this court, as well as other courts, have noted that the immigration judge's duty in a pro se matter is heightened compared to other cases. And here, you do not have the immigration judge arising to that duty, where there must be at least...
The government indicates that that was an argument never raised until your reply brief. Is that correct?
No, Your Honor.
That is in your brief?
Yes. The immigration judge had a duty to at least, at the bare minimum, point the pro se respondent to a case or afford him an opportunity to spend some time at the law library. If there must be at least some articulation or advisal as to what constitutes a viable or cognizable particular social group, shouldn't we, in a more complex inquiry, in the, quote, crimmigration side of this practice area, which of course under Padilla, Kentucky, was noted by the Supreme Court as only being in diminished complexity to tax law. And if you have an individual who is attempting to fight off removal himself and cannot even respond to the evidence being presented against him with respect to loss thresholds, or even that the loss threshold is a determinative question, he won't stand a chance, just like Judge Dennis noted in his concurring opinion in Canterbury Lagos, that if pro se respondents were left to their own devices to construct social groups, none of them would prevail. And if you have a crimmigration issue, in this case an aggravated felony that creates a per se particularly serious crime, barring them from asylum, barring them from withholding of removal under the Act and withholding under the Convention Against Torture, leaving only deferral, and the pro se respondent has no idea as to why, and then ambiguously in his handwritten brief says, I disagree that my criminal history should bar me from seeking this type of relief, and then for the board to respond to that with respect to withholding under CAT, that opens the door for this court to consider that argument. And that is what I submitted in my brief, and I do believe that the issue was not waived. The Ninth Circuit in Enrique Rivas said that, however inartfully pleaded, that there should be some additional liberality afforded to a pro se respondent when dealing with issue preservation and the...
You would have that liberality, or whatever you call it, mean that the IJ needs to act as the counsel to the petitioner.
No, Your Honor. I'm simply...
Represent him and do his case for him.
I'm advocating...
He's still the IJ. That means the immigration judge.
Yes, Your Honor. I see my time has expired. But I ask that this court remand this case for proper determination of the likelihood of torture due to the notoriety and the political position of the respondent in this case, and also find that the immigration judge failed to advise in any respect the dispositive issue with respect to barring him from relief from asylum, as well as withholding of removal under the Act, due to an aggravated felony determination, and specifically the loss threshold question in this case.
Thank you,
I thank
counsel.
the court for its consideration,
All right,
and with that, I conclude my argument.
counsel. If you wish to come up, we will adjourn court and have you all come up.